Good morning to all of you. Andarki Shubhodayam. Welcome to Legal Matters by Sai Babu Sukar. This video relates to filing of amendment petition at the last stage, which can be accepted if the court thinks that there is material, but normally should not be accepted when it is filed for protracting the proceedings, delaying the proceedings purposefully. If it is for the purpose of delaying the proceedings, not allowed, should not be allowed. This is what is stated by Allahabad High Court. In the case of X versus Y, on 22nd May 2025, Justice Vivek Chaudhary and Bijraj Singh amendment petition at the final stage is against the spirit of Order 6, Rule 17 of the Code of Civil Procedure. You know, Order 6, pleadings. Rule 17, amendment of pleadings. Amendments of pleadings can be done at any stage if the original structure of the suit is not disturbed. That's why in the classes, final students, please remember, in the 5th semester during the CPC class, I told you specifically, one day we have taken for rule number 17, amendments. I told you that the amendment can be allowed up to the issue of framing of issue stage. Later, normally not allowed during the time of trial. Here it is filed the last time. So let us go to the factual scenario so that you can be able to understand. Why this is X versus Y means because both of them are actually wife and husband. Normally, therefore, they mentioned as X and Y. I will tell you the names also. Right. The High Court set aside the order of the family court, which allowed the amendment petition after 10 years, that too in the final stage. He filed the petition after 10 years. Right. It is a first appeal under Section 19 of the Family Courts Act 1986 against the order of the Family Court Judge Lucknow under Section 13 of the Hindu Marriage Act 1955. Right. So actually, for the sake of convenience, I am telling you the name of the appellant is Brijesh. Anyway, the marriage between Srimati Meenu Rajvamshi, she is the wife, with Brijesh was conducted on 1/5/2011 at Lucknow as per the Hindu rites and rituals. And when she went to the marital house, she was demanded the additional dowry and also some cash and also car also. She could not digest or she could not withstand the harassment of the in-laws, and therefore she left the matrimonial home and came back to her house. There she gave a police complaint which was registered as crime number 17/2013. This happened in the year 2003. 17/2013, after 2 years of marriage. It was registered under sections 498A, as you know, harassment, 504 and 506, that is criminal intimidation of the IPC, and also section 3 and 4 of Dowry Prohibition Act. Then, in this connection, the police arrested them, they filed the charge sheet, and the court also took cognizance of the matter. This is one stage of the criminal trial. ఇప్పటివరకు నీకు అర్థమై ఉంటుంది. క్రిమినల్ కేసు ఇప్పుడు దాకానే చెప్పింది. She filed a case. Since the disputes have cropped up, ఇంకెందుకులే లాభం లేదులే అని చెప్పి she filed an OS, original suit, for divorce under Hindu Marriage Act. So, since both of them are living separately, so she filed an OS on 29/7/2014. right? And in this connection, he filed, the husband, that is Mr. Burjesh, he filed a lot of various applications to summon that witness, to summon this witness, to summon related. Each and as well. But in a civil case, when you are able to ask for the summons, you must be able to produce them. If they are not willing to receive the summons in civil case, we cannot do anything. It is your duty to procure the witnesses. It is your duty to get the summons served on them. It is your duty to see that they attend the court. It is your duty that they depose. Of course, having received the summons, if they don't attend, మీకు ఆర్డర్ 16లో క్లియర్గా సెక్షన్ 25 to 30A డిస్కషన్ చేసి చెప్పాను. Right. So he filed various applications to summon that witness, to summon that document, but the trial court rejected the same. Right. Then meanwhile, she went to the High Court. Under Article 226, she approached the High Court, and the Honorable High Court addressed the issue by directing the trial court to complete the trial within 4 months. But this man once again filed an amendment petition under 6 Rule 17. For what? For allowing him to set up his counterclaim. So once again you come to Order 8, Rule 6A, counterclaim. Set up under counterclaim. నాది కూడా కేసు ఉంది, అది కూడా తీసుకోండి అని వేయడానికి ఈ ఫైల్ ద అమెండ్మెంట్ ఎట్ ది లాస్ట్ స్టేజ్. ఇన్సిడెంటల్లీ ద ట్రయల్ కోర్ట్ టుక్ ఇట్ ఆన్ ఫైర్. అబ్జెక్టింగ్ టు దిస్ ఉమెన్ హ్యాస్ కమ్ టు ది Allahabad High Court. Now the High Court clearly, the family court allowed it on 21/9/2024. High Court said it is surprising. Please remember to note that for the last 10 years he kept silent, and when the proceedings are at the final stage, now he moved an amendment petition against the spirit of the law, against the spirit of the Code of Civil Procedure, which is not at all. Actually, it is nothing but or only to delay the running proceedings to harass his deserted wife. She is running from pillar to post for the last 10 years. Why Order 6 Rule 17 is in good spirits? పొరపాటున ఏదన్నా జరిగితే, unless the court comes to the conclusion that in spite of due diligence, ఇది సెక్షన్లో కూడా ఉంటుంది, ఒకసారి చూసుకోండి. The court has come to the conclusion that in spite of the due diligence, the party could not raise it at the initial stage. And secondly, the structure of the case will not change అన్నప్పుడే చేయాలి. What is this అని చెప్పి High Court has set aside the orders of the family court. Of course, they have given directions that the family court should dispose the matter within, once again, I think day-to-day basis, within 2 months, they have to decide. Very important decision in favor of Order 6 Rule 17. Normally allow అంటారు, అది allow చేయక్కర్లేదు. Interpretation was given in this. So please read the case law and enrich your legal knowledge. ఇలాంటి కేస్ లాస్ మీరు కంపల్సరీగా చదవాలి, లేకపోతే ఇబ్బంది అవుతుంది. ఇది మనకు చాలా ఉపయోగపడేది. సో ప్లీజ్ రీడ్ ఇట్. ఓకే, మోర్ దాన్ దిస్ ఐ డోంట్ వాంట్ టెల్ ఎనీథింగ్. థ్యాంక్ యూ.